The court therefore grants the government's petition for mandamus. Judge Boasberg loses and vacates Jeb's probable cause order. The judge didn't have the jurisdiction to issue an order against Trump to do what he said to do, and then holds in criminal contempt for that. It's lunacy.
We have right in 20 kilograms of fentanyl that's in front of me on this table. That's enough to kill 10 million people.
Big victory from the Trump DOJ announced by Pam Bondi, saying our Justice Department attorneys just secured a major victory defending President Trump's use of the Alien Enemies Act to deport illegal alien terrorists. Now, the D.C. Circuit Court of Appeals, we're going to go through the decision, affirmed what we've been arguing for months, that Judge Boasberg, and I'll remind us of who he is, in his attempt to sanction the government for deporting criminal alien terrorists was a clear abuse of discretion, something we've been screaming here for months. We will continue fighting and winning in court for President Trump's agenda to keep America safe. This is called a mandamus. Now, we're going to see kind of a couple of different issues in the appeal and in the order. One is kind of about the jurisdiction of the appeal. And so Trump was saying a couple things. Like, one, we're appealing that lower level order, which is terrible and wrong. And also, we're filing kind of a separate claim that's pretty much the same, but it's for a writ of mandamus. And so we're asking you, higher court, to tell the lower court, you done acted a fool. And so that's what this is called. It's called a mandamus. You done acted a fool, I think. I don't know. It says it is an order from a court to an inferior government official, ordering the government official to properly fulfill their official duties or correct an abuse of discretion. Now, according to the DOJ, they say mandamus, according to their manual, is an extraordinary remedy. Like, the court's never granted because it's a lot. It's like you're going to tell another judge they were wrong, which should only be used in exceptional circumstances of peculiar emergency or public importance. So the fact that this was successful against Boasberg shows just how bad this is, right? In federal courts, these orders most frequently appear when a party to a lawsuit wants to appeal a judge's decision but's blocked by rules. Instead of appealing, the party simply sues the judge, seeking mandamus, compelling the judge to correct a mistake. You were wrong. Generally, this type of indirect appeal is only available if there's no alternative means. Now, the All Writs Act gave the Supreme Court and all courts established the authority to issue these. So, extraordinary remedy. In other words, we don't grant this just willy-nilly. You got to do something pretty bad before we get there. That's according to Cornell Law School. So, here is the order that has come down. Now, two of these judges were Republican judges, and one of them, I think, was an Obama judge. And this is the order. We also have the full memo that we'll take a look at. All right. Upon consideration of the emergency motion for a stay pending appeal from the Trump DOJ, or in the alternative, a writ of mandamus, or either appealing it, or we need you to come in here and correct this separately. The motion to dismiss the appeal, we've read it all. We've read the letter. We've read the supplements. We've done further fact finding and all the things. And so now that we're here, we've read the briefings, and here is our decision after considering all of this. It is hereby ordered that some people can come in and participate as amicus. A little anticlimactic on that one. But it is also further ordered that the motion to supplement the record on appeal be granted so we can continue to develop this. Now, it's further ordered, and you might read this saying, the motion to dismiss the appeal be granted. You say, oh, Trump's appeal got dismissed. Oh, no. And, though, that the petition for a writ of mandamus be granted. Boasberg blown out. Bad boy Boasberg. And the district court's contempt-related order entered by Boasberg on April 16th is vacated. Punk, in accordance with the per curiam opinion that we'll take a look at next. Separate concurring opinions of the other judges, Katsas and Rao, and the dissenting opinion of Circuit Judge Pillard accompany the opinion. Now, a grant of mandamus relief will become effective, and the administrative stay will dissolve 21 days after the issuance of this order, so get your affairs in order, Jeb. The emergency motion is dismissed. You don't need an emergency motion. You're not appealing anything because we just gave him the old legal backhand. Bad boy. The clerk is directed to withhold issuance of the appeal-related mandate herein until 7 days after, and there could be, right, a petition for a rehearing on this on bonk, which means we want to bring in the full panel, not just the three judges who decided this. So, Jeb Boasberg having a rough one today, and let's take a look at the memo from the District of Columbia, the D.C. Circuit, United States Court of Appeals, saying bad boy Boasberg. So, with a little bit of a summary here at the beginning, they say, all right, per curiam, this is the opinion of the court. This matter in front of Jeb is arising from challenges to the government's removal of Tren gangbangers. They say Trump entered an illegal order and a proclamation saying that they're terrorists under the Alien Enemies Act. So what happened is we saw this. Trump comes in, a couple months later, gangbang lawyers come filing in here, crashing into the courts like clown cars. 5 alleged gangbangers sued on their own behalf and as representatives. They got an order that was proposing a class of all of the gangbangers, saying you have to halt our removal. Now, that same day, Boasberg, that judge, he held an emergency hearing. We remember, go, what? He didn't even give the DOJ really an opportunity to respond. And he came out, he said, oh, gangbangers, love you guys. Yeah, you're a class now. You're certified as a class. And there's a temporary restraining order. Trump, the duly elected president who has lawful authority and in many cases valid orders of removal, can't remove anybody because I'm the president now, says Jeb, barring their removal. The government nonetheless flew class members from the United States to El Salvador and transferred them to the custody of the Salvadoran authorities. Now, I might take issue with that, right? I think that's framing it in favor of Jeb Boasberg. We remember in this one, and I think they're going to get into it, but there was a battle over this. Like, Jeb gave the order orally, verbally in court. He said, turn those planes around. And they said, oh, is that like what you're going to order? Okay, so I guess we'll wait for your written order and you'll tell us exactly what you want us to do, and then we'll do it. But until that time, we're going to continue our deportations, obviously. So once you tell us what we can stop and not do anymore, we're going to continue to do what we're doing. But according to the government, the temporary restraining order from the judge barred only the removal of class members from U.S. territory. And that had already occurred before the TRO was entered. Okay, DOJ said, no, we didn't violate anything. Okay, they were already in the air. They were already across national lines. So it's not your jurisdiction anymore. You don't have power. So sorry. According to the district court, the judge said, I do have power. It did bar removal of class members from U.S. custody. Okay, it wasn't about the physical territory. It was about custody. And you still had custody of them down in CCOT. So put them back on a plane and bring those gangbangers back. And the government likely violated it, said Jeb, by transferring class members to CCOT and El Salvador. So then in response to these events, the district court Judge Jeb, he came out and he issued an order accompanying opinion, and he found probable cause, remember, which is like a crime, that some federal officials willfully violated the TRO. Well, I think there's evidence of criminality here. And so we're going to have an investigation because you violated my order, which was illegal and totally invalid. I mean, and also undefined in many ways. Now, the court offered the government an option to purge the putative contempt by taking custody and bringing them back. Remember, the Supreme Court said, you're wrong, Jeb. Sorry, you lose. You don't have the authority to tell the president to return people who are already out of the country. So stop that. The judge said, okay, fine, I won't. I guess I was wrong. But at the time I issued my order, you violated it. Okay, so now it's been reversed, but you should have still followed the order, is the argument. Because you think about it from a public policy perspective. They don't want people to say, well, I'm just going to ignore the order pending appeal. No, you got to follow the order, and then you can undo it after the appeal is over. So the judge went and found a bunch of case law and said, well, I guess I can still prosecute you for this, and did so. So now we're on appeal. Now, the court also stated that if the government says we're not going to purge this, in other words, the judge said, you can comply, again, with my illegal order, and then I will stop my illegal contempt proceedings against you. And he's like a federal judge who just is still on there having a straight face. Maybe he has a straight face. I don't know. He might be laughing himself to sleep every night. I don't know. But it must identify the executive branch officials who, aware of this court's TRO, made the decision not to halt the transfer of class members out of custody. The court further came down and they said, you know, the next step, says Boasberg, is we're going to request that contempt be prosecuted by an attorney for the government, right? He's going to unleash the DOJ to be prosecuted by the DOJ. And it stated, if the government declines or in the interest of justice requires, the court will appoint another attorney to prosecute the contempt case. The judge will appoint like an independent counsel, some sort of special, officer of the court to prosecute somebody or something. Now, the government appealed this. They said, there's no probable cause order, judge. You can't make this up, Jeb. And they moved for an emergency stay on appeal or a writ of mandamus, saying you have to tell this judge like he's acting ridiculous. You have to terminate these criminal contempt proceedings right now. So they then moved to dismiss the appeal, and the court granted the stay, and here we are. Now, the court writes, we grant the motion to dismiss the appeal. The panel's unanimous because we don't have appellate jurisdiction. Okay, like this is not a proper appeal. We can't do anything on the appellate rules. But Judge Katsas and Judge Rao do conclude that the government, the DOJ, has satisfied, remember those exceptionally stringent requirements for the writ of mandamus. It's an exceptional remedy. The court therefore grants the government's petition for mandamus. Jeb Boasberg loses and vacates Jeb's probable cause order. Judge Pillar dissents, very unhappy about this, from the grant of mandamus and the vacatur. Now, this case involves an extraordinary ongoing confrontation between the executive and the judicial branches. Yeah, thanks to them. Trump is actually just executing the laws of the presidency to which he's entitled because he won the election. Jeb didn't. On March 15th, Trump sought to implement a proclamation. And there were planes of 100 alleged gangbangers flying out of here. They said, bring him back. The judge said, you violated my orders. Now, in response to these events, Judge Jeb issued criminal contempt contempt proceedings. He said, well, if you then follow my illegal order, then I will not hold you in contempt anymore. Now, at the end of all of this, we're familiar with what happened, lies a much simpler question. Here's the question. By its own terms, did Jeb's order, did his TRO, did it prohibit the government from, quote, removing gangbangers? This prohibition could be interpreted in either of two ways. It might have barred the government from simply expelling detainees from the territory, or it might have been custody. But Jeb doesn't give the DOJ any benefit of the doubt, right? There's no presumption of good faith between the branches anymore because there's a judicial coup and insurrection happening by these judges under the color of law. And then they are holding it in default against Trump, presuming there's some maliciousness, presuming there's some criminality, not giving them the benefit of the doubt, the good faith basis for believing that they were actually interpreting it correctly. Judge just goes, up, contempt, prosecute. All agree that the government did not violate the TRO under the former view. If your crap order, Jeb, you should have been more specific about it. If it is territory, then Trump is valid, totally fine. So the contempt question boils down to a straightforward interpretive dispute over what actually constituted removing within the meaning of the TRO. And it's pretty incredible how much these illegal aliens, right, get all these benefits, all this analysis about what is removal for them, Tren de Aragua, Judge Boasberg, like all this analysis for them when it's clearly already been in Trump's power to do it. For purposes of criminal contempt, ambiguities in the underlying injunction must be resolved in favor of the alleged contemnor. So if we see that Trump does have a hole in the line of scrimmage that they can run through and say, oh, that's our argument right there. We didn't remove anybody from the territory. They were already out of the territory. So we followed your order to the T. Oh, got us. Okay, so that's one interpretation of it. So you have to give them the benefit of the doubt. You can't hard charge them with crimes for that. At the time of the alleged contempt, just hours after the TRO hearing and before any transcript was even available, the minute order could reasonably have been read either way, Jeb. Thus, the TRO cannot support a criminal contempt conviction here. You can't just make up ambiguous orders and then hold people in criminal contempt. The government has sought review of this order, and they're doing it by mandamus. Now, there is no basis for appeal right now, but mandamus is appropriate because the government, Trump, is plainly correct about the merits of the criminal contempt argument. And our saying so now would prevent long disputes between the executive and the judiciary over these difficult, contentious issues and over foreign policy questions and criminal sanctions for violating injunctions. Your injunction was entered without jurisdiction. I'm so happy they said that. Or to impose criminal sanctions for violating injunctions entered without jurisdiction, okay? The judge didn't have the jurisdiction to issue an order against Trump to do what he said to do and then holds in criminal contempt for that. It's lunacy. Now, in circumstances much less fraught than these, courts have reviewed orders through mandamus to prevent this extended interbranch conflict, which has come out from the judge. He never had jurisdiction. For these reasons, I concur in the order, granting the petition for mandamus and vacating the probable cause order. He says, now, I am also concurring in this. This case arises in the midst of a high-stakes clash between Jeb and Trump. In March, Trump issued a proclamation ordering the removal of members of Tren. The following day, they did remove. But while the removal was in process and after 2 planes had already left the United States, Jeb entered a TRO. He said, don't remove anyone. The Supreme Court then vacated the TRO, holding the district court lacked the authority to issue it. The Supreme Court says you don't have the power, Judge Jeb. That should have ended it. It didn't. Of course, he took it. He said, yes, I do. Get out of here. Were you the Supreme Court and the president? What are you talking? I'm the president. Despite the Supreme Court's decision, Jeb sought to remedy what it perceived, Jeb did, it's him, perceived as the executive's non-compliance. Relying on its criminal contempt authority against the co-equal branch of government, as we say, the court issued an order finding probable cause that the government officials at the DOJ willfully violated the order by not turning the planes around. No, you should have gone right into the pilot and said, flip this around. Well, we're in the middle. We don't have fuel. We got to land over here. We've got international agreements. They're expecting us at this time. Too bad. Bring them back because I'm Jeb and I love illegals in our country. The order offered the government a choice. You can follow my illegal order. You can come into compliance with my vacated TRO, such as by asserting custody over the individuals detained in El Salvador. Okay, so I don't have authority to do it normally, but I will use my other contempt power that I'm just pulling out of my Boa's butt and then trying to create around a new allegation against you to enforce the original TRO. Or 2, identify the officials responsible. So you either comply or you tell us who we're going to charge with criminal contempt, and the judge will appoint a prosecutor to do it. And you'll prosecute yourselves for not following my illegal order. And this is like the Democrat hero, right? They are in favor and supporting these judges, defending them. They call this law and order. They call this a threat to democracy. You can't criticize these judges, they're judges. They're impartial, blah, blah, blah. You can see it right here. It's right on its face. It's illogical. The district court's order, says this judge, is a clear abuse of discretion, and it does warrant the drastic and the extraordinary remedy of a mandamus. Ooh, Jeb. Punishment through criminal contempt might still be available in these circumstances, but the judge cannot use the threat of that punishment as a backdoor to obtain compliance with a vacated and unenforceable TRO. It's a scam. So the district court's abuse of the contempt power is especially egregious because contempt proceedings against senior executive branch officials carry profound separation of powers overtones and demand the most sensitive judicial scrutiny, which this judge doesn't care about. None of them have because they're, in my opinion, Democrat hacks. Lacking the authority to compel obedience, the district court nonetheless pressured the government to take custody of the alleged aliens that were already out of our country. This intrusion on the president's foreign affairs authority constitutes an unwarranted impairment of another branch in the enforcement of their duties. Because this order exceeds this court's authority to do it and amounts to a clear abuse of discretion, mandamus is appropriate. And he's going to give us some analysis on this. What is an overreach? Assessing the lawfulness of this order, we have to understand what Jeb did. The district court claimed it was undertaking, quote, a compliance inquiry. He's like, all right, let's see what Jeb actually did here. A compliance inquiry? He says the government was disobedient of my TRO, and I'm going to punish you with contempt. Now, after applying the standards for criminal contempt and determining there was probable cause to find a willful violation, he said, follow my orders or else. Now, the purpose of this was to force the executive branch into doing something. Now, the court acknowledged that it can no longer coerce this action because it was vacated, but it did use its contempt powers. Dangling this sword of Damocles to compel the executive exceeds the court's authority and is an abuse of discretion. Over from Judge Rao. The rule of law depends on obedience to judicial orders. But shortly after the district court granted their order, they disobeyed it. Now, our system of courts cannot endure if we let people defy court orders with impunity. That's not what happened here. There's a reasonable interpretation about what the order actually said. Trump interpreted it to his benefit. The judge didn't like that. That's not Trump's problem. The judge should have written a better order. When it appears that a judicial order has been disobeyed, the court should look into it. And the district judge, he says, in defense of our courts, issued an opinion describing in detail, but colleagues now vote to dismiss this. And this is an error. It would be even more apparent that they have not met a writ of mandamus. The standard is so high, and it's not actually a criminal contempt order anyways. All it did is start to investigate this, okay? In other words, it's not criminal prosecution. He just wants a declaration to know who did this, and he is just investigating the crimes. And Trump could have voluntarily provided all sorts of things to them, and they didn't. And so now Trump is saying we actually complied with this, and so, you know, this dissenting judge says they didn't. So we'll see. Now, this might go up for further appeal. We'll see what the illegal gangbang lawyers decide to do. But Chad Mizell over from the DOJ, in responding to this, is responding to Senator Shelton Whitehouse. Whitehouse sent this one in. He said, why did I send this letter to the Chief Justice? Remember, Judge Boasberg was also the same judge that was in the room with John Roberts and saying, you know, this judge is amazing. And we're not going to read his little crap letter. Now, Kristi Noem was out. Kristi Noem, of course, responsible for a lot of these deportations and the removals of these Tren de Aragua gangbangers and illegal aliens. And here is what she had to say with all this drug and cash contraband laid out in front of her.
The contraband that's in front of me, we have right in 20 kilograms of fentanyl that's in front of me on this table. That's enough to kill 10 million people. And here out of this office, this was interdicted just days ago here in Illinois. And because these federal officers have been out on the streets picking up criminals and dangerous individuals, we were able to take this 20 kilograms of fentanyl off the streets and save over 10 million lives. They're also keeping these weapons out of the hands of criminals that would use it to rob and assault and to murder individuals in these communities. Unfortunately, all of the politicians that have spoken out against their efforts, their desire appears to be that they would like to have more of this on their streets.
They do.
More drugs out there for their kids and families to be victimized. More guns out there committing crimes. That is not the work that we do in ICE. The work that we do is to protect people and make sure that we remove these weapons and drugs off of our streets and hold those criminals accountable who would go forward and continue to use that to harm individuals.
All right, so well done to Kristi Noem. Shout out to Pam Bondi and the DOJ. Very nice victory here, and we'll see what happens, right? If this goes back up to a full panel, we might see some appeals, so there might be a further litigation on this, but as it stands, big victory. Judge Boasberg, one of the worst judges that we've been covering here in this new modern modern era who's been exercising his authority like a tyrannical person is now reversed and scolded, basically, okay? It's an abuse of your discretion, Judge, just like everybody has been saying for a long time on our side. You guys have been saying, this is about preserving the Constitution, and all your stuff, which is not even constitutionally literate. These are illegal aliens. They've gotten plenty of due process. They want due process premium. It's like they've never even heard of the concept before. But Boasberg, blown out, big victory. We'll keep our eye on this stuff.